Hi, everyone, and welcome back to another deep dive.
Great to be here.
Today, we're really getting into something crucial for understanding how religion is handled legally, specifically here in Spain. We're going to unpack Professor Rafael Palomino's analysis of Article 3.2 of Spain's Organic Law of Religious Freedom, the LOLR.
Yeah, and Palomino's work is, well, it's quite timely, isn't it? The LOLR just had its 40th anniversary.
40 years, wow.
Exactly. And that milestone naturally prompts reflection on, its journey and its impact. It's important to remember, too, that despite some pretty strong criticism back between, say, 2008 and 2010, the law wasn't actually scrapped.
Right, they didn't replace it.
No. Instead, they opted for some regulatory reforms in 2015, sort of fine-tuning certain technical aspects.
Okay, and that's precisely the mission for this deep dive, to really get a handle on the role the LOLR plays in the legal treatment of religion in Spain. We'll be focusing specifically on Article 3.2, and particularly how it impacts religious groups.
And what's really valuable about Palomino's analysis, coming from an expert in ecclesiastical law, is the perspective it offers. It looks at what might seem like a very technical point of Spanish law, but it actually reveals some, surprising insights into how Spain legally defines and approaches religion itself.
All right, let's kick off with something that really struck me. The unusual longevity and stability of this law, the LOLR. It was passed way back in 1980, right? To flesh out the fundamental right to religious freedom found in Article 16 of the Spanish Constitution.
That's correct. And if you compare it to other organic laws that developed fundamental rights after the Constitution, well, most of those were wrapped up by 2002. The LOLR has shown remarkable staying power.
And according to Professor Palomino, it certainly faced its share of ideological challenges, particularly during that 2008-2010 period. There were even proposals to replace it entirely with a law on freedom of conscience. What were the main arguments driving that push for such a big change?
Well, four main reasons were generally cited. First, the need to adapt the law to Spain's growing religious pluralism.
Second, this idea of a deepening state secularism. Third, equating religious beliefs with non-religious convictions. And finally, it was seen as a chance to regulate conscientious objection.
But Palomino suggests there was maybe a deeper reason behind those arguments, something about the perception that religious freedom granted certain privileges, particularly to the Catholic Church.
Exactly. The author's interpretation is that some saw religious freedom as a mechanism allowing religions, especially the Catholic Church, to maintain special rights. So there was a desire to shift towards regulating ideological freedom under common law, essentially removing that perceived special treatment.
But there were also arguments for keeping the LOLR, or at least parts of it.
Yeah.
What were the main counter-arguments?
People pointed to the broad political consensus that enabled the law's passage back in 1980.
Right, the historical context. Yes, and also a positive view of religion as a valuable social phenomenon in its own right, plus the constitutional principle of cooperation between the state and religious denominations. There were also suggestions for improvements that, didn't necessarily require a whole new organic law.
And Professor Palomino seems to think the later regulatory reforms, the ones in 2015, already address many of those more technical points. Does he believe the real aim of those pushing for a new law was something else entirely?
Yes. His view is that the push for a completely new law was actually aimed at a more fundamental transformation of the system, essentially trying to neutralize that principle of cooperation, which has been a defining feature of church-state relations in Spain.
Okay, let's talk more about the role of the LOLR within the Spanish legal system itself. We know it was one of the first laws developing fundamental rights after the 1978 Constitution.
That's right, and it had very broad political backing at the time, a really strong vote in its favor. Structurally, the law has two main parts. The first part, Articles 1 through 4, outlines the fundamental components of religious freedom itself.
The core rights.
Exactly. The second part, Articles 4 through 8, deals with the collective aspect of religion, how religious groups get legal personality, their internal autonomy, those cooperation agreements with the state, and the Advisory Commission on Religious Freedom.
And the author draws an important distinction between these two parts, doesn't he? One, developing the fundamental right, the other, regulating the legal framework for collective religion.
Correct. Palomino emphasizes that, from the perspective of an organic law, the first part truly develops the essential content of the right, while the second part primarily regulates the legal framework for collective religious life. It's a key distinction, although, importantly, he notes the Constitutional Court hasn't always strictly maintained this separation, particularly concerning registration.
Right. The registration aspect seems crucial. This brings us to the 4 stages Palomino identifies in how Spain has legally treated religion over time. Let's start with the first. That inertial predominance of the Catholic Church from 1978 to 1992. What exactly does he mean by that?
He's describing a situation where, following the democratic transition, the Catholic Church still held a dominant position. Both quantitatively, most Spaniards identify as Catholic, and qualitatively, due to deep historical and cultural ties with the state and society.
So, a factual observation.
Yes. Palomino stresses it's a descriptive observation of the reality then, not a value judgment. He contrasts this with views linking secularization strictly to imposing a rigid secular state model. He sees the LOLR, born in this period, as a seed for future evolution towards greater pluralism. Essentially, in these early years, the LOLR operated in a landscape still heavily shaped by the Church's historical influence, setting the stage for later adjustments as religious diversity grew.
Then comes the second stage, 1992 to 2001, which she calls the emulation of the extensive paradigm. What happened during these years?
This was when minority religious groups started actively seeking formal relationships with the state, kind of following the model the Catholic Church had already established. A pivotal moment was the signing of the cooperation agreements in 1992 with several denominations. Exactly. And Palomino uses this interesting phrase, suggesting a somewhat forced attribution of notorious rootedness, notorio rego, to the religious federations, rather than maybe the individual confessions themselves. This effectively created a new category of registered confessions, those with cooperation agreements, which had significant implications for their specific legal standing.
The third stage, 2001 to 2015, is described rather dramatically as a legal earthquake and a period of unilateral state action. What was this earthquake?
The earthquake refers to the Constitutional Court's ruling 4-6-2001. This ruling was hugely significant.
How so?
Well, it established that registration in the Registry of Religious Entities is actually part of the fundamental right to religious freedom in its collective dimension. Critically, it also ruled that the registry's role is merely to verify formal requirements.
Not to judge beliefs.
Precisely.
Yeah.
No controlling beliefs. And the public order clause couldn't be used preemptively to block registration. This ruling basically forced a major overhaul of the registry in 2015 and also led to the formal regulation of notorious rootedness as a more defined legal status via another decree that same year.
Okay.
Then, voluntary jurisdiction law, also in 2015, cemented this notorious rootedness status, allowing civil recognition of religious marriages for groups with this status, even if they didn't have specific cooperation agreements. Essentially, that court ruling fundamentally shifted the power dynamic regarding religious registration. It became a protected aspect of religious freedom itself, not just a discretionary state decision.
And that leads us to the fourth and current stage, which Palomino labels uncertainty. Why uncertainty now?
The uncertainty stems largely from the ongoing case involving the Church of the Flying Spaghetti Monster.
Ah, yes, Pastafarianism.
Right. Palomino suggests that if this, let's call it parody religion, were to win its case for registration, it could push towards a purely formal, self-referential concept of what constitutes a religious confession, and by extension, religion itself in legal terms.
A logical consequence of the earlier ruling.
Potentially, yes. A consequence of that 2001 Constitutional Court ruling, the idea being if the state can't legally determine which religion is true, perhaps it also can't define what religion is for registration purposes.
Fascinating implications. Okay, let's drill down into the core of today's discussion. Article 3.2 of the LOLR. Professor Palomino sees it as a kind of bridge between the organic and non-organic parts of the law. Why that analogy?
Because Article 3 as a whole deals with both the limits of the right to religious freedom, that's in Section 1, and the exclusion of certain activities from its scope of protection, which is exactly what Section 2, Article 3.2 does. So it acts like a hinge, connecting the definition and potential limitations of the fundamental right itself with the regulation of the collective aspects of religion.
Right. Let's read Article 3.2 so we all have it clear. It says, activities, purposes, and entities related to the study and experimentation of psychic or parapsychological phenomena, or the dissemination of humanistic or spiritualist values, or other similar aims unrelated to religion, are excluded from the scope of protection of this law.
It's a text that actually sparked some debate when the law was being drafted. Some groups argued, like the Andalusian group at the time, that humanistic and spiritualist values aren't always so easily separated from religion. They pointed to Spiritism as an example.
But that view didn't win out.
No, it didn't. What's interesting, though, is that similar clauses Clauses trying to distinguish the religious from other similar social phenomena have appeared in religious freedom laws in other Ibero-American countries, Mexico, Colombia, Peru. This suggests they serve a practical purpose in applying the law.
So how do legal experts interpret Article 3.2? It sounds like there are a few different takes on its function.
There are indeed. Some see it as a kind of negative definition of religion for the purposes of this specific law.
Defining it by what it's not.
Exactly. Others view it as setting a broad limit on religious freedom in its collective manifestation. It's also been suggested it helps differentiate more traditional religious expressions from newer or less conventional ones. Another interpretation is that it distinguishes between collective entities with religious aims and others with similar but non-religious aims, granting special autonomy only to the former.
Okay.
Some argue it correctly describes activities the law doesn't intend to protect under the religious freedom umbrella, despite maybe some vagueness in that phrase, other similar aims unrelated to religion. And perhaps one of the most significant interpretations is that this article is key for distinguishing religious freedom from ideological freedom at the collective level.
But it's crucial to stress this article doesn't mean individual humanistic or spiritualist beliefs are left without any legal protection, does it?
Absolutely not. Palomino is very clear on this. Article 3.2 doesn't imply that individual beliefs or convictions of this nature lack legal protection under the broader framework of freedom of thought or conscience, which is also constitutionally recognized. Interpreting it otherwise would clash with international human rights standards.
Like the UN Human Rights Committee.
Precisely. Their General Comment 22 and Article 18 of the ICCPR protects a very wide range of theistic, non-theistic, and atheistic beliefs, and explicitly warns against discriminating against newer or minority religions.
So what's the core practical purpose of this article? Why did the Spanish legislators feel the need to include this specific exclusion?
Essentially, Article 3.2 is a pragmatic solution to the inherent difficulty of defining religion exhaustively and universally. It was simply more workable for the legislature to state what is not considered religion under this specific law, particularly for collective purposes. Remember, the LOLR aims to develop the fundamental right to religious freedom and regulate the legal status of collective religious entities. This article prevents other belief systems or worldviews, which might have superficial similarities, from automatically falling under the same specific legal framework that Western European law generally reserves for religious groups. It functions as a tool to demarcate the law's scope and preempt boundary issues in practice.
I see. It's like a way to avoid having to make judgments on a case-by-case basis about what counts as a collective religion eligible for specific legal treatment.
Exactly. Palomino notes that an amendment proposed during the law's drafting, which saw judicial assessment of the phenomena listed in 3.2, was rejected precisely because the legislative intent was to exclude them directly from the LOLR's protective scope.
Yeah.
And while there was concern that some religious organizations might also have humanistic or philosophical aims, the key for applying the article lies in determining if those non-religious aims are the primary or predominant purpose of the entity.
Professor Palomino calls it a utility clause, rather than a definitive statement, especially relevant for the registry of religious entities. How does the Constitutional Court's jurisprudence fit into this?
The Constitutional Court, through its interpretations, has consistently held that the state's role in the registration process is essentially one of mere verification or constatation.
Just checking the boxes.
In a way, yes. Checking that an applicant entity doesn't fall into one of the categories explicitly excluded by Article 3.2. The state doesn't have the authority to assess the legitimacy or authenticity of a group's religious beliefs to grant or deny registration. Its function is limited to confirming it's not primarily an entity focused on parapsychology or disseminating humanistic spiritualist values or other similar non-religious activities as defined by the law.
So, to sum up, Article 3.2 reflects a specific Spanish constitutional reality. Broad protection for all individual beliefs aligning with international norms,
Right.
but a particular recognition and treatment for religious beliefs at the collective institutional level. And this is because the Constitution mandates cooperation specifically with the Catholic Church and other confessions, not just any collective worldview.
Precisely. The cooperation envisioned by the Constitution is with entities primarily understood as religious. This necessitates a distinction from other organizations that, while perhaps sharing similar values, aren't structured as religious confessions for the specific purposes of the LOLR.
So wrapping things up, what's the main takeaway we should draw from this analysis of Article 3.2?
I think the main conclusion is that Article 3.2, although it might look like a minor technical detail within the larger law, is actually a critical piece in defining the scope of religious freedom protection in Spain, especially for collective entities. It reflects a deliberate legislative choice to distinguish religious groups from other organizations with potentially similar-sounding aims, particularly for purposes of specific legal recognition and state cooperation.
Okay, and a final thought for our listeners to ponder. How does this legal distinction we've discussed, especially excluding humanistic and spiritual pursuits from the specific protections the LOLR offers, religious entities reflect broader ideas about the relationship between belief, identity, and the state? Does it create clear boundaries, or does it leave significant gray areas, especially for evolving spiritual or belief-based communities today?
That's certainly a crucial question to keep thinking about. We definitely encourage listeners interested in digging deeper to look at the full text of the LOLR and the related court rulings. It's a complex but very relevant issue.
Absolutely. And on that reflective note, we'll leave it there for today. Thanks so much for joining us on this deep dive.
My pleasure.
Until next time.